Hello everybody, welcome to Juris Desk India. Today we have come up with a case law, Keshavananda Bharati versus State of Kerala 1973, which was decided by the largest bench of Supreme Court of India, that is 13 judges bench. The majority of the decision was held as 7-6. So what is this Keshavananda Bharati's case? What does it say? Its citations runs as follows in the brackets 1973 4 SCC 225. Who is this Keshavananda Bharati? What does this case say? The Keshavananda Bharati was a Hindu monk. There was a mutt called Ednir Mutt in the state of Kerala. He was head of that mutt. In the time of 1973, there was a legislation passed in the state of Kerala. What is that legislation? The Kerala Land Reforms Act 1973. What the provisions of legislation say? The legislation restrained the individuals of Kerala that one individual should have only this amount of property, the threshold amount of property. If one has above the threshold amount of property, the property will be seized by the government. So now, what happened with Keshavananda Bharati? Keshavananda Bharati, being head of Ednir Mutt, has owned some amount of property in the name of the mutt. Now, in the name of the mutt, whatever the property he has owned is seized by the government because it was above the threshold amount of property which was given in Kerala Land Reforms Act. So now, Keshavananda Bharati has gone to Supreme Court of India under Article 32. What he says? He challenges that this act is violative of fundamental rights of Indian Constitution because at that time the right to property was incorporated in 19 clause 1 clause F of Indian Constitution. So now, what does the judge say? The judgment runs as follows. The judges said that whatever the law passed by Kerala government, that is Kerala Land Reforms Act, is valid. Why? Because if there is no Land Reforms Act, rich start becoming richer, poor start becoming poorer. So whatever is done by the government is valid, and it is also upheld the 24th amendment that Parliament of Kerala has all the rights to amend fundamental rights of Indian Constitution. So this is Keshavananda Bharati's case in a brief way. You know what? Keshavananda Bharati has lost his own case. He did not win his case. So, in that judgment also, the basic structure doctrine was introduced by Supreme Court of India, which was enlisted many provisions or many points which are called as basic structure, which should not be amended by any parliament, that can be central or state. So this is what Keshavananda Bharati's case very briefly. For more of such content, follow Juris Desk India and reach out to us at jurisdeskindia@gmail.com. We will help you with any case law or any legal provision or any legal awareness. So subscribe us on YouTube and follow us on Instagram. Thank you so much. Thanks from all the team of Juris Desk India.